All right, welcome to a video on contract law. And this is something that it's actually coming more out of necessity than anything else. It's just something that keeps recurring with our clients and obviously prospects as well. It's just not understanding when they've entered into a contract, when they've entered into a binding agreement, and whether or not what they've got is in fact a contract. And so we're just going to broad strokes go over the high level details of what a contract is, the key elements, and give you a little bit of understanding there. This is not to be considered legal advice. I'm afraid I have to give that disclaimer. If you aren't sure after this video, please do speak to us. And yeah, with that, let's take it away. So there's 5 key elements. The first is offer, acceptance, consideration, capacity, and intention. We're going to go into each of these in a little bit more detail. So first one being offer. First of all, it needs to be an offer that is possible to be accepted. If I don't verbally communicate it, if I don't communicate it in writing, it's not possible for the offeree to accept. So just sort of common sense. And some of this might sound so common sense that you can't believe it. It's in legal universities and texts, but it's important to know these things. So the second would be the reasonable person test. So there is a basis for a subjective test, but as you see, a subjective intention is irrelevant. Rather, if it's disputable whether or not an offer was made, then the consideration is objectively on what happened, as well as would a reasonable person have seen this interaction, document, communication as being an offer, and there's case law to substantiate what that would be. The next is acceptance. So for acceptance to take place, the offer needs to still be open, so not rescinded, not conditional. Acceptance needs to be on the same terms. If, for instance, I offer you or I propose that you would be allowed to rent my home for £200 a month, and you come back and offer me £100, that would not be acceptance. If, however, you said, perfect, I accept £200 a month, sounds just fine, that would be more along the lines of being acceptance. It needs to be unequivocal. So you can't say, well, I agree, but it depends on whether or not I get this job. I agree, it depends on whether or not I'm allowed into the country. Maybe not the best examples, but those are some of the examples we've seen. It needs to be unconditional, so a lot like unequivocal. It needs to be clearly communicated. So if the offerer is not aware of the offer or the acceptance rather, then clearly no acceptance has taken place. It can also be that the offerer says you must accept in, for example, written format on a blue piece of paper, which sounds like a terrible example, but that would be an example of how it could go about. Another one would be, and this is more common, where you might get an email that would say, to indicate that you accept this offer, simply a reply agreed below, or rejected if you do not. And so to show acceptance, you would only need to write agreed, right? So that's a couple of examples there. Now, if you've got offer and acceptance, you have an agreement, but you don't yet have a contract because you need the other 3 essential elements, starting with consideration. So consideration is a promise, an act, or a promise not to act. So this is where it gets important. There needs to be a clear exchange, and it needs to be something for something. So you can't you can't have if there's no exchange of value from one party to another, then no consideration has been exchanged. It could also be an act, so like an employer to an employee, or a restrictive clause in a contract, restraint of trade. That would also be a promise not to act, and those all can have values attached to them. The next would be capacity. So capacity is, as it says there, it's more of a negative requirement. A legal person is an individual of a major age, so 18 and older, or a company, a trust, etc., etc. However, a legal person can be disqualified in certain events, for instance, mental disability, bankruptcy, being an insolvent company, or being a company who's no longer in operation, just as a few examples. And then there are restrictions on, for instance, a director of a company might be allowed to make decisions in certain instances, but not in others. And those are sort of the restrictions that might come about for capacity. Obviously, for individuals, you need to be of a certain age, and those sorts of things. Then there's intention. So this is less of an obvious clause, offer, acceptance, capacity, and consideration. Those are fairly clear. Intention is where the other four are present, but one of the parties says, well, they didn't actually mean to, which is a very colloquial way of saying they didn't intend to enter into the contract. And there needs to be an objective test for this. So did the offeree accidentally type agreed when they meant to type rejected? And they would need to prove that was the case. Did they say that sounds great, but obviously they didn't say yes, we agree? The burden falls on the person claiming that they had no intention to enter into the contract. Another terrible example would be that someone else answered their email. They'd need to prove that happened. And it's quite a complicated process to go through. And it's very rarely a remedy when you'd like to basically prove that a contract wasn't entered into. And those are, broad strokes, the elements of a contract. Now, it's not exhaustive, it's very high level. And in most cases, we find we need to consider what the client has in writing before we can advise them on whether or not they have a contract, as well as what the contract actually says. But this should give you a little bit of power when going into your next agreement, purchase, or sale. Until next time.